Hi everyone, this is Mateo Botero. With Taylor Correa and Gregorio Restrepo, we are going to expose the Convention on Biological Diversity. This convention started in 1992 during the Earth Summit of Rio de Janeiro, also known as Rio 92, but it officially started to operate in 1993. In 2003, it happened the Cartagena Protocol, and in 2014 the Nagoya Protocol. But what is the CBD? It has been conceived as a practical tool for translating the principles of Agenda 21 into reality. This convention definitively recognizes the biological diversity, that it is much more than only plants, animals, and microorganisms and their ecosystems. Because for the CBD, biodiversity it is about people and our need for food security, medicines, fresh air and water, shelter, and a clean, healthy environment in which to live. This convention has three main goals. The first one is the conservation of biological diversity. The second, a sustainable use of the components of biological diversity. And third, the fair and equitable sharing of the benefits arising out of the utilization of genetic resources. This according to the 1993 Convention on Biological Diversity Foundation document. This secretariat is organized by two conventions that are Cartagena and Nagoya, but also has the constantly advice of the IBs. That is the group of experts that are supporting all decisions of the policymakers inside the convention. And we also have the UN Decade on Biodiversity that is mostly supported by the CBD. The first extraordinary meeting of the CBD took place in Cartagena in 1999. However, the protocol that got the name of this city was finalized and adopted in the 2000 in Montreal, Canada. This protocol is also known as the Biosphere Protocol because it seeks to protect biological diversity from the potential risks posed by living modified organisms resulting from modern biotechnology. The Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits arising from the utilization to the CBD is a supplementary agreement to the convention. It provides a transparent legal framework for the effective implementation of one of the three objectives of the CBD, especially or exactly the fair and equitable sharing of benefits arising out of the utilization of genetic resources. And in the map, the blue colored countries means the parties. The green, the countries that signed but they didn't ratify it. And the gray, not signatory. The UN Decade on Biodiversity provides an overarching framework on biodiversity, not only for the biodiversity-related convention, but for the entire United Nations system and other partners engaged in these issues. And we have one of the major groups that is Global Youth Biodiversity Network. This is the official group for youth in the negotiations under the CBD. It is committed to bringing the opinion of youth from all over the world and their positions in the political process, empowering young people to take action, and it is actually recognized and supported by the CBD Secretariat.
Now, we will discuss the relationship between international law and the Convention on Biological Diversity. The CBD is an international legally binding treaty. The treaty affirms that the conservation of biological diversity is a concern for all of humankind and encourages parties to take actions towards a sustainable future. The CBD's supplementary agreements include the Cartagena Protocol and Nagoya Protocol, which Mateo mentioned previously. I will also like to highlight some important characteristics of the treaty. First, the origin of the CBD text highlights an important quality of the document. Since it was open for signatures during the United Nations Conference on Environment and Development, the treaty had originally been introduced as a multilateral effort. That brings me to my next characteristic. The CBD is a multilateral environmental treaty since more than 3 sovereign states are parties. Lastly, the precautionary principle is a crucial aspect of environmental law, which is also included in the text of the CBD. Environmental law often works in complicated areas because it incorporates scientific uncertainty and predictions. So, the precautionary principle requires that if there is a strong suspicion that a certain activity may have environmentally harmful consequences, it is better to control that activity now rather than to wait for incontrovertible scientific evidence. The treaty also includes certain principles of just law, which we covered in class. One of the examples that is often repeated is sovereignty. This principle is mentioned several times in the preamble and throughout the text. An example includes in Article 4, which states have, in accordance with the Charter of the United Nations and the principles of international law, the sovereign right to exploit their own resources pursuant to their own environmental policies, and the responsibility to ensure that activities within their jurisdiction or control do not damage to the environment of other states or of other areas beyond the limits of national jurisdiction. Another principle of just law that is emphasized is equality. The preamble recognizes the important contribution women can make in an effort to promote equality. In the preamble, the CBD states, quote, recognizing also the vital role that women play in the conservation and sustainable use of biological diversity, and affirming the need for the full participation of women at all levels of policymaking and implementation for biological diversity conservation. It also recognizes that developing countries will need additional aid to allow them to implement sustainable practices. In that way, it recognizes that it needs to level out the playing field. In the preamble, it also states, quote, acknowledging further that special provision is required to meet the needs of developing countries, including the provision of new and additional financial resources and appropriate access to relevant technologies. Not every country has ratified the treaty. 2 member states of the United Nations are not parties to the CBD or BSP, which stands for the Cartagena Protocol on Biosafety. Those countries are the United States of America and the Holy See, the Vatican. In total, 196 parties have ratified the treaty, and South Sudan recently joined. You might be wondering, what entities are judicially responsible for the implementation of the treaty? Judicial enforcement, according to Article 27, includes that if contracting parties need to settle disagreements over the interpretation or application of the convention, parties are encouraged to seek negotiation. If a negotiation cannot be made, they are expected to use a third party to mediate. However, if negotiations are still not possible via a third-party mediator, a state or regional economic integration organization can declare through writing to the depositary that this dispute was not resolved and may accept one of the following 2 dispute settlements. 1. Arbitration in accordance with the procedure laid down in Part 1 of Annex 2 in the document, and 2. Submission of the dispute to the International Court of Justice. You might also be wondering, how does the convention ensure compliance and cooperation amongst all parties? The Compliance Committee was created in response to that need as a vital aspect of the Nagoya Protocol. The Compliance Committee, under the provisions of the Nagoya Protocol, can receive submissions relating to issues of compliance and non-compliance with the provisions of the protocol from A. Any party with respect to itself, B. Any party with respect to another party, and C. The COP-MOP. The COP-MOP is a conference of the parties serving as the meeting of the parties to the protocol, which is why it stands for COP-MOP. It currently meets every 2 years in addition to the regular conferences parties host for the Convention on Biological Diversity. To date, the COP-MOP has held 9 meetings.
Okay guys, so as Mateo said, the case study we are going to review today is a territorial dispute between Costa Rica and Nicaragua over a 3-kilometer area of wetlands. So back in 2010, Costa Rica instituted proceedings before the International Court of Justice against Nicaragua, claiming the unlawful incursion and serious damage to protected rainforests and wetlands as a consequence from Nicaragua's excavation of a navigation channel in that area. So Nicaragua responded back in 2011 with similar claims against Costa Rica, claiming not only violation of sovereignty but major environmental damage from a road construction Costa Rica was doing in that same area at the time. In 2013, the court then joined both cases and issued a provisional order to the two countries to abstain from having any activities in the disputed area. However, Nicaragua decided to continue the excavation of 2 additional navigation channels, going against the court order. So then the court had to allow Costa Rica to take any necessary measures, including force, to prevent irreversible damage to the environment. And this was done following consultation of the Ramsar Convention, which is a very important convention on wetlands and the protection of those type of ecosystems. So in 2015, the court ruled in favor of Costa Rica and declared Nicaragua's activities unlawful under international law. Both parties, however, failed to reach an agreement on the compensations for the damage, and new proceedings had to be brought to the court over these compensations. Costa Rica claimed compensations for the quantifiable environmental damage as well as for the costs and expenses it had to incur in trying to prevent Nicaragua's damage to the environment. However, Nicaragua argued that Costa Rica was only entitled to material damages, and those were damages that could be assessed in financial terms. However, Costa Rica, and this is where the CBD comes in place, argued that the ecosystem approach had support under international practice. And to support this theory, it noted a decision from the Conference of the Parties of the Convention of Biological Diversity, which stated, and I'm quoting here, liability and redress rules might also address the loss of ecosystems' ability to provide actual or potential goods and services. The court then viewed that the loss of ability of the environment to provide goods and services was indeed compensable under international law, and concluded that Nicaragua had an obligation to fully repair Costa Rica for the environmental damage caused by these acts. So this is important when seeing it through a hard versus soft instruments perspective of international law. Since a convention such as the CBD is intended to be international law and falls within the hard law category, at least in theory, as it constitutes international instruments that are regarded as prescribing binding obligations. However, it's the theory of some scholars that at the time the CBD had an approach by countries of being a soft law. It has been typically been regarded as soft law since it focused on global biodiversity targets and not on obligations. However, as said before, the importance of this case and of the ruling of the court on this issue is that it put back in place the CBD as a hard instrument of international law, as a treaty that must be followed by all countries. So that's why the CBD is important under international law.
One of the questions we have discussed since the beginning of class is whether or not international law is effective. Even though we have come across examples where international law may not be the most effective for carrying out important agendas, we believe that the Convention on Biological Diversity proves that international law can be effective when we are discussing the environment. And with that, thank you for listening to our chat, and we hope you walked away with something new. Goodbye.